bond.
Yes, sir.
I filed a good motion setting forth that, she's got no prior criminal record. She's
Let
a
me take a
lifelong
look
resident.
at, let me take a look at her, at your motion on her behalf.
Yes, Your Honor.
Are you ready on that? I didn't
I
even.
am.
Okay,
And she's here.
all right. All right, thank you, ma'am. You can come down if you want to and hear better, ma'am. If you want to sit here on the front row, you can do that.
And I'm sorry.
No, you go right ahead, Mr. Talley.
I looked at the bail and bond statutes over the weekend.
Yes, sir.
And there are only two statutes that address GPS monitors, 40-11-150 and 40-11-152.
All right.
They talk about it specifically. And the offense that she's charged with, accessory after the fact, is not one of the offenses that's noted for requiring a GPS monitor. And I'll stop talking about for reasonable motion. There's a number of other reasons in my motion why she shouldn't have to wear it. It's just a great inconvenience. She'll always be important, always has been.
All right, now, you're not saying under 150 or 152 that it is not allowed, but it's not mandatory. Is that what you're saying?
Well, it's not a enumerated offense under 152.
So, okay.
It's,
Let me look, do you have a copy of that statute?
I
probably
brought this, Your
would
Honor.
be,
Brought this.
much better off reading it. Yes, come on.
Thank you, Your Honor. That's 150 and this is 152.
All right, thank you.
Yes, Your Honor.
Carol, you're still looking at the law on this? All right, go right ahead and let me know.
Yeah, I don't add for background court, this bond and this GPS requirement were imposed before Kenny Wayne DeHart was found with the police and put in jail. Her dad posted this bond for her. Corporate surety bond, didn't want her in jail. And at the time was a terrible, tragic event, you understand that. Nobody's, my clients that had no hand in that. But I know the families here, we've always said nobody had any more sorrow than my client. It's about what happened here again. Bond is to secure your appearance in court, show up. She's gonna be there. There's $350,000, right? And her record is perfect. She I said in my motion, as always lived here, I'll put her in the road, go back. Everything in this motion is true.
I take it as true you've represented to the court, Mr. Talley.
Yes, sir.
For purposes of this hearing, I'm gonna let them stay. When they're finished reading these, tell me what their position on this is.
The court has the authority on it in their GPS as a condition. This is talking about a specific instance with certain victims, but the court has general authority to set both the financial component and any other components that are reasonably related to securing the defendant's appearance in court. This was done in General Sessions Court, I think there, I believe, Your Honor, there was a hearing. I don't believe there was an agreement at the time on the bond. I think the court said it after a hearing, but I wasn't present for that.
Batchers said.
Sorry?
I think Batchers said.
I'm not sure. My understanding from General Murphy is it was set in court, but I'm not sure.
It's whatever the order is, whoever said it,
Right.
said it. It's currently the order.
And this is reasonably related to the circumstances that are underlying offenses are the most serious there are, Your Honor. And I don't need to go through the facts, but the warrant in this case alleges that she said they're here when there was a phone call from Mr. DeHart. I know, speaking with the family, they certainly feel safer having this condition, Your Honor. And it's not so onerous under these circumstances that the court should consider state cases any change in the law.
Mr. Talley, anything further?
Yeah, I'd only add that what happened in that short period of time, the true facts have never come out. She of course, she got a call, my client got a call from Mr. DeHart, when the police had to stop alongside the road, and that call went about 7 minutes. Now, 16 minutes passes, he calls back and says to her, I've been shot, I fired shots, I'm not gonna survive. I'm gonna die here. That's what he told her, that's 8:40. Now, 9:57, a SWAT team descends upon her house. I'm not certain, I know more than 25 officers. She's in police custody. Is still in police custody. Police have her telephone. Call comes in. It's from Kenny Wayne DeHart's niece. They asked her, who is that? Tells her that's his niece. Says, would he be with her? She says, I don't know. She has her child in her arms crying. Being in custody of the SWAT team's no small matter. She's never been confronted with anything like that. She's distraught, under extreme duress. They had the phone, she answers, and she spontaneously, knee-jerk reaction, they're here. That's what happened. That's the entire offense she committed right there. That's what the facts will prove. Go ahead.
No, I was just going to say, certainly that may be her position, and that's something for the trier of fact to determine. Based on the circumstances of the officers who were there present at the scene when this was happening, they sought to obtain warrants for accessory after the fact to homicide, Your Honor, and aggravated assault. They were present when this happened.
They're only charging you accessory after the fact.
Right, that's what I'm saying. Aggravated accessory after
The court has read the motion, has read the law that Mr. Talley has provided. The state's had an opportunity to see that as well. In this case, she is charged with accessory after the fact. She is not charged with the homicide itself. However, this court recognizes the gravity of the underlying charge to the primary defendant and the related charge in this case. Bond can be considered by the court, the facts relative to flight for an individual to show up. The bond has been posted at $350,000, which is a large bond for an e-felony. However, the issues in this case, the close ties of this defendant to the primary offender, gives rise to a much greater risk in the mind of this court for flight, for failure to appear. And the court does not, the court first rules that the court has authority, as the state's position is, to order a component of a bond to be a GPS monitoring system. The court finds that in cases of this nature to be appropriate in certain circumstances. Secondly, the court specifically finds in this situation it is appropriate given the gravity of the entire situation and the need for this case to move forward and the defendant to appear before the court on the dates so assigned. So the court, for all those reasons, the risk of flight being greater given the nature of this case, the court does deny the motion, allows the order from General Sessions Court to remain in place, and the GPS monitoring will remain in place.
Thank you, Your Honor.
In this case, and do we have another court date for her?
Yes, it's already set.
It's already set?
We're set at 10.
9:23, it looks like. All right.
Yes, sir. Thank you very much, Your Honor.
Thank you.
Good to see you, Your Honor.
Good to see you, Mr. Townsend.